morning, my lord. I'm number 983293 with Sergeant Major Stolle. Quarter guard mounted by another central DHQ composed of 1 guard commander, 1 guard 2IC, and 11 sentries, all formed up in a single rank, ready for inspection, my lord. Thank you, my lord. quarter guard of the legal year 2026. Permission to dismiss, my lord. Thank you, my lord. Osan Parade. Quarter guard, dismiss.
Constitutional Court Act, Chapter 723, Section 27 of the Supreme Court Act, Chapter 730, and Section 47 of the High Court Act, Chapter 706. The Honorable Chief Justice has directed that the Superior Court of Zimbabwe shall sit at such places and at such times as specified in General Notice number 1408 of 2025 and General Notice number 1409 of 2025 respectively, and that the first term of such courts shall commence on the 12th of January 2026.
Thank you. The Prosecutor General, Mrs. Justice Matanda Moyo, the Attorney General, Mrs. Mabiza, Advocate Martinella, distinguished guests, ladies and gentlemen, it is a distinct honor to welcome you all to the official opening ceremony of the 2025 legal year. The official opening ceremony of the legal year is now part of the annual judicial calendar. The occasion enables the judiciary to communicate with the nation and interact with all stakeholders for the first time in the new legal year. The judiciary looks back at the year 2025 as a period marked by important transformative developments in the justice delivery system. These included the continued decentralization of the courts, the expanded implementation of the integrated electronic case management system, investment in staff welfare and training, and the strengthening of key institutional frameworks that support the work of the courts. The year 2025 also marked the final year of implementation of the Judicial Service Commission's Strategic Plan 2021 to 2025. Under that roadmap, a number of initiatives were planned, including the decentralization of the courts and the digitization of court processes through the deployment of IECMS and associated reforms. Those aspirations were in large measure achieved. The achievements realized under the strategic plan can only lay a firm foundation for the new strategic planning cycle. From the onset, it must be stated that the successes would not have been possible without the cooperation and input of the Commission's stakeholders. The judiciary expresses its profound appreciation for the support rendered by its many stakeholders throughout the implementation of the 2021 to 2025 strategic plan. The accomplishments outlined in the present transformative state of the judiciary, as at the end of 2025, are the product of collective effort of justice sector institutions, development partners, and the public that we all serve. In 2025, the Commission administered the courts under the theme, Court, Building Public Confidence in the Judiciary through Multi-Stakeholder Participation, unquote. The theme, rooted in the Constitution's founding values and principles, focused on advancing constitutional compliance in the justice delivery system. It underscored the need for the judiciary and all stakeholders in the justice sector to expend their energies on making decisions and taking actions prescribed by the law in order to build and sustain public confidence, not only in the judiciary, but in all justice sector institutions. It is pleasing that the objectives underlying the theme were largely achieved during the period under review. That was particularly important because 2025 also served as the year during which the Commission took stock of the work undertaken over the 5 years covered by the 2021 to 2025 strategic plan. In the various review exercises and consultations that took place, multi-stakeholder collaboration consistently emerged as a central factor in the progress that was recorded in the justice delivery system. The theme for the 2026 legal year is as follows, quote, using performance management and technology to ensure quality, inclusive, and sustainable judicial service, unquote. As has been observed in previous years, the theme is a product of careful thought. It is designed to streamline areas of focus and priority for the judiciary. All themes that have been identified by the judiciary to date are contextual. They are based on a triad comprised of the Commission's broader vision, its constitutional mandate, and the context within which it is operating. The legal year theme for 2026 places performance management and technology at the center of court operations. The significance of the choice of the two means will be explained later. At this stage, it suffices to mention that their selection as components of the theme for 2026 is the outcome of such institutional reflection. It is a declaration of the Commission's commitment to adopt performance management and technology as strategic tools for the achievement of a truly principled judicial service defined by quality, inclusivity, and sustainability. The theme places emphasis on the principle that judicial trust must be translated into demonstrable performance, and that modern tools must be harnessed lawfully and ethically to achieve the aim. That is a strategic imperative derived from the Constitution itself and the statutes, given that the judicial service is a sui generis form of public service created by law to vindicate fundamental human rights and freedoms and to give effect to the rule of law. It is a framework designed by the law for the specific purpose of upholding the law for the benefit of the people. The law demands that public institutions must act in the public interest, and in the case of the judiciary, that it is kept in a high state of efficiency. It imposes specific obligations regarding the impartiality, integrity, and accountability of all those who exercise judicial authority. As such, the adoption of performance management and technology as strategic enablers for the elevation of judicial service to the required standards requires accountability to the law and not the convenience for the judiciary. That said, it is therefore incumbent to set out in careful and explicit terms the vision of the judiciary that the Commission seeks to constitutionally build. That vision must be premised on principles, it must be measurable and realistically achievable. It is through defining what that vision is that the Commission can ensure that performance management is deployed to assess that which truly matters, and that technology is utilized in the service of enduring institutional purpose rather than simply for novelty's sake. The judiciary's vision is anchored on constitutional foundations. Section 162 of the Constitution declares that judicial authority derives from the people of Zimbabwe and is vested in the courts. The primary object of Section 162 is to set out the reason why judicial authority is exercised. It is for the people of Zimbabwe. Section 165 of the Constitution sets out principles that guide the judiciary. Some of those principles are that justice must be done to all irrespective of status, that justice must not be delayed, and that the courts must safeguard human rights and freedoms and the rule of law. In addition, Section 190 of the Constitution sets out the objectives and functions of the Commission. It provides that the Commission must promote and facilitate the independence and the accountability of the judiciary and the efficient and transparent administration of justice in Zimbabwe. The provision vests in the Commission the powers necessary for that purpose. Having vested judicial authority in the courts, the people of Zimbabwe then set out in Chapter 8 of the Constitution the principles and the values that they expected the judiciary, that they were constitution, to embody. Those principles reflect the system of justice delivery envisioned by the people of Zimbabwe and expressed in the constitutional text. It is that constitutionally grounded vision that the 2026 theme seeks to translate into concrete priorities for the coming legal year. In practical terms, the legal year theme is the bridge between the constitutionally based vision and the day-to-day priorities of the judiciary. The theme speaks to strategic and operational refinement of the Commission's long-articulated vision of a Zimbabwe in which world-class justice prevails, driven by both judicial and administrative excellency. The aspiration towards world-class standards is not an exercise in institutional self-interest, but is fundamentally service-oriented. This is because the judicial authority is a component of state power created by the sovereign people for their benefit. As such, the judiciary's vision is fundamentally broad and transformative to ensure that every adopted strategic priority vindicates the public trust endowed by the people. Thus, the modern judiciary that the Commission is building must be capable of delivering justice as a matter of right, whilst being accountable at three distinct but mutually associated levels. Firstly, It must be legally accountable to the Constitution and enabling statutes. In addition, it must be operationally accountable through adherence to measurable and results-oriented performance standards. Thirdly, it must be ethically accountable through good governance frameworks that protect fairness and judicial independence. Ultimately, this accountability framework is in service of the public, who are the sovereign source of judicial authority. The understanding affirms that this vision is not merely for the public officials associated with the judiciary. The people embraced the reform and transformation of judicial processes as part of the constitution-making process. Therefore, every reform must be judged by its effect on the lives of the ordinary people who seek judicial remedies to vindicate their rights. The conceptualization of the judicial's vision aligns with the Commission's mission statement, which emphasizes promoting a transparent, accessible, and independent judiciary that inspires public confidence in the rule of law. Thus, the theme for 2026 is an articulation of how the vision will be transformed from an aspiration into an enduring reality. It directly connects operational excellency with the judiciary's broader constitutional mission. Given the constitutional mandate, the service rendered by the judiciary must adhere to non-negotiable standards. Quality, inclusivity, and sustainability have been identified as the preeminent standards for the measurement of the success of initiatives to reform and improve the provision of judicial service in 2026. These concepts operate both as standards and as outcomes of judicial service. They are standards in that they embody the quality of judicial service that must be delivered. They are outcomes in that adherence to the principles that constitute them is manifested through their presence in the administration of justice in Zimbabwe. The first defining standard and outcome of judicial service, given its nature as created by law for the benefit of the people, is quality. Quality represents the principles embedded in the Constitution regarding the nature of justice that the people of Zimbabwe expect from the judicial service. It is intrinsic to the proper performance of any judicial task and is a fundamental requisite of every public office. It is not sufficient for justice to be delivered. It must be delivered to a standard that inspires public trust in the legal system. In the context of judicial service, quality is not an abstract measure of excellence. It is a composite standard defined by both the conduct of the office holder and the integrity of the judicial process. As alluded to earlier, quality also encompasses the integrity and competence of those who serve. Where competence is lacking or integrity is compromised, the judiciary fails in its duty to deliver quality justice. Personal behavior must be regulated by the standards of office, because the credibility of justice depends as much upon the integrity of those who serve as upon the soundness of the institution they serve. The requirement of competence and integrity as a measure of quality is not a novel concept. It is drawn directly from the Constitution. Section 165, subsection 2, stipulates that members of the judiciary, individually and collectively, must respect and honor their judicial office as a public trust and must strive to enhance their independence in order to maintain public confidence in the judicial system. This ethical obligation is strengthened by Section 165, subsection 6, which mandates members of the judiciary to give their judicial duties precedence over other activities and to shun activities that may impinge on those duties. In relation to competence, Section 165, subsection 7, mandates all members of the judicial service to take reasonable steps to maintain and enhance their professional knowledge, skills, and personal qualities, and in particular, to keep themselves abreast of developments in domestic and international law. These provisions enshrine the ethical and professional standards that underpin competence and integrity as measures of quality. Inclusivity is the second pillar of the judicial's vision. Compliance with its requirements demands that the concrete ways in which judicial service delivery is organized must ensure that no one is left without access to an effective forum for the vindication of fundamental rights and freedoms. Inclusivity speaks to who is able to use the system of justice. As a pillar of judicial service, it is premised on the constitutional imperative set out in Section 165, 1A, to the effect that justice must be done to all, irrespective of status. At its core lies the democratic promise of equal treatment of everyone before the law. This foundational principle mandates that judicial service must not be regarded as a privilege reserved for a few. It is a non-discriminatory right and a public good available to all members of the public. Properly construed, inclusivity is a measure of the judiciary's reach and of its commitment to leaving no one and no place behind. The foregoing ideal is entrenched in Section 56(1) of the Constitution, which provides that all persons are equal before the law and have the right to equal protection and benefit of the law. The provision recognizes the inherent worth and dignity of every person as the foundation for equal treatment before the law. It binds all providers of judicial service, whether an individual is performing a judicial function on the bench or an administrative function in support of the courts. Their duty is to treat every person strictly in terms of the law and to do so equally. Equality in that context requires attention to the plight of marginalized groups, such as persons with disabilities, the elderly, children, women, and the poor, whose circumstances may create specific barriers to the enjoyment of rights. In addition, inclusivity through access to justice involves extending the reach of judicial service to the general populace by removing all barriers to its use. A judicial system that is inaccessible, unaffordable, slow, or whose procedures are incomprehensible to the people who are expected to benefit from them, effectively denies those people access to justice. The concept demands that there be no physical, financial, linguistic, or technical barriers that frustrate litigants. This involves recognizing and specifically addressing the needs of those who historically faced systemic disadvantage. Processes must be sensitive to and accommodative of the unique needs of vulnerable populations, including women, children, persons with disabilities, and the elderly. A truly inclusive system adapts to the user, not vice versa. Finally, inclusivity can be personified by the blindfolded lady justice statue, which symbolizes that justice must be administered in accordance with the law, without bias, regardless of gender, wealth, power, or social status. Cases must be decided purely on the basis of facts and the applicable law. Justice embodies inclusivity when everyone is treated equally and everyone is judged fairly, impartially, and objectively. The third defining standard and outcome is sustainability. If quality is the standard of how and when the service must be delivered, and inclusivity speaks to the non-discriminatory availability and accessibility of the service to everyone, sustainability speaks to how it can be ensured that the gains achieved endure. Sustainability concerns the ability of the justice delivery system to provide high-quality judicial service to everyone all the time, thereby guaranteeing social cohesion and stability. It speaks to the need to address fundamentals and to put in place arrangements that have permanence and resilience. The Constitution, which embodies the foundational values and principles inspiring the justice delivery system, is a transformative document designed to endure. Its preamble records a determination to secure a better future for Zimbabwe and its generations to come. That intention has direct implications for the manner in which justice is administered. The interpretation and application of the law must be progressive and future-oriented. The law must be read and applied as part of a living constitutional order. Decisions taken today must not wrongly disadvantage the children who are born tomorrow. In practical terms, sustainability requires that the institutions and the systems that support the judiciary and the judicial service are capable of withstanding pressure and embrace change. These include sustainable investment in infrastructure, information and communication technologies, human resources, training, and wellness. Central to the idea of sustainability is the understanding that the judiciary must be insulated from corrupt practices, both internally within its administration and externally in attempts to influence its decisions. Corruption fundamentally undermines both quality and inclusivity, rendering the entire judicial service vulnerable to attack and discreditation. The system must be robust enough to withstand ethical breaches and retain public trust, given that public confidence is the bedrock on which judicial authority must be anchored across generations. When quality, inclusivity, and sustainability are understood in this manner, they emerge not as abstract ideals, but as concrete standards and outcomes that define what judicial service must be and what the judicial service must continuously strive to achieve in order to realize the constitutional vision of a prosperous and sovereign Zimbabwe in which world-class justice prevails. Having set out the three pillars that must support the desired vision of judicial service, it is clear that quality, inclusivity, and sustainability emerge as standards imposed by the law itself. They are not optional aspirations. They are legal standards. The principal question that the judiciary must consistently pose is how judicial service is to be organized and managed so that it answers to these standards in practice. In addressing that question, objectivity, measurability, and lawful accountability are indispensable. It must be able to be demonstrated with verifiable data and transparent processes that the judicial service provided to the public conforms to the articulated standards. Standards of this nature cannot be left to intuition or assumptions. They must be made visible through systems that can be tested and verified. For this purpose, the Commission has identified performance management and technology not as ends in themselves, but as the most direct, scalable, and complementary means by which the quality, inclusivity, and sustainability of judicial service will be measured and sustained. These instruments will be deployed within strict governance frameworks and constitutional safeguards so that performance evaluation and digital innovation serve the rule of law, protect judicial independence, and strengthen public trust. Both means will now be addressed, focusing on their relevance to the Commission's objectives for 2026. Conceptually, performance management is the expression of the Commission's commitment to lawful accountability and good governance in the execution of the public trust. It is a crucial means chosen to ensure consistency between the service defined by the law and the service actually delivered by public office holders. In the judicial context, performance management is not mere administrative routine of filling in forms or compiling statistics. It is a lawful and structured framework through which the judiciary and the Commission ensure that judicial service fits together with the constitutional standards already identified. Performance management is the mechanism through which the high standards set out for justice delivery are connected to the actual service received by litigants and the public. It seeks to guarantee that the service delivered is of high quality, meeting defined legal and professional standards such as the timely and consistent issuance of judgments and orders. The need for such a coherent system is not theoretical. It arises from concrete experience. In the case of the judiciary in Zimbabwe, performance management emerged as a prominent area of concern during developments in 2025. Between February and October 2025, the Secretary of the Commission embarked on an extensive monitoring and evaluation exercise across the Superior Courts, the Office of the Sheriff, and the Harare North and South provinces in the Magistrates' Court. This was an exercise meant to analyze and assess the effectiveness and efficiency of the judiciary's processes as they render court services to the public, especially court users. The long-term monitoring and evaluation exercise exposed several systemic shortcomings. They included inconsistent work allocation in registries, inaccurate and unreliable statistical reporting, thousands of dormant and abandoned processes clogging workflows, and substantial gaps in the updating of matters on the IECMS. Staff indiscipline and unethical conduct were additional and serious concerns at certain magistrates' court stations. These findings compelled immediate and comprehensive interventions. All High Court registries were restructured, and specialized desks were established to ensure structured workflows. Duties were delineated between registrars and deputies, with standardized reporting formats rolled out across stations. A strategic redeployment of staff alongside intensive targeted training was also undertaken. The Chief Justice issued Practice Direction Number 1 of 2025 as a decisive initiative that enabled the dismissal of 6,524 dormant matters in the High Court. Such dormant matters comprised cases filed by parties who then made no effort at all to prosecute their suits, which they left lying idly in the registries for inordinate periods, running into months and in many instances even into years. Serious concern is expressed at the conduct of litigants, especially legal practitioners who file matters with no intention at all of prosecuting them. Such conduct is unethical and is unexpected of officers of the court. The monitoring and evaluation process also resulted in the archiving of physical files in the divisions of the High Court because of the digitization of court processes. As part of the more long-term interventions, senior leadership in the registry was deployed to underperforming stations to stabilize operations. The outlined findings and the corrective actions undertaken by the Commission demonstrate precisely why performance management is indispensable and must be central to judicial reform in 2026. It is one of the most critical mechanisms by which the Commission intends to holistically assess the judicial service in order to detect shortcomings, direct training and resources, enforce standards, and strengthen public confidence in the administration of justice. The judiciary cannot simply assume that standards are being met. It must be able to assess the position on the ground and demonstrate it through objective measures that are scientific, legally sound, and institutionally credible. From its inception, the Commission has recognized that performance management is a constitutional response to the demands of the law, not an optional accessory. When the Commission was established, it inherited a generic performance appraisal system used across government departments. Over time, it became evident that the specialized nature of judicial work required a system tailored to the judiciary. This led to the development of a homegrown performance management framework for the judicial service, incorporating both quantitative and qualitative indicators such as case management efficiency, backlog reduction, staff welfare, and the state of court infrastructure. The Commission is now integrating the integrated results-based management system as the principal performance management framework for the judiciary, linking planning, budgeting, monitoring, and evaluation to clearly defined results. This is also the system that the government of Zimbabwe has adopted under the whole of government approach as a tool to assess performance for public institutions. In this sense, performance management is best understood as a system that creates institutional connection and coherence. It ensures that what is done in research, registries, courtrooms, administrative offices, and support services departments fits coherently into the constitutional mandate specified in Section 190 of the Constitution and into the broader national development agenda. It is a bridge between strategic vision and the daily execution of tasks. The theme for 2025-26, therefore, finds grounding in Section 9 of the Constitution, which requires the state to adopt policies that develop efficiency, competence, accountability, transparency, personal integrity, and financial probity in all public institutions. Of particular relevance is Section 9, subsection 1b, which obliges the state to take measures to expose and eradicate corruption and abuse of power by public officials. In the judiciary, performance management is one such lawful means through which the constitutional obligation to expose and eradicate corruption may be fulfilled. It transforms aspirational qualities into quantifiable and enforceable public duties. More specifically, it ensures that those entrusted with judicial authority discharge their duties to the required standard and that failures are identified, addressed, and remedied. That approach is further reinforced by Section 194 of the Constitution, which sets out the fundamental principles governing public administration. The Commission's statutory mandate to maintain the judiciary in a very high state of efficiency is the institutional expression of that constitutional requirement. Performance management must, however, be recognized and practiced as a lawful system. The measures adopted under it must be consistent with the Constitution and with ordinary law. They must respect judicial independence, uphold fair labor standards, and comply with the principles of justice that the judiciary itself is mandated to protect. Any performance management tool or practice that undermines constitutional standards, for example, by impeding access to justice, interfering with judicial decisions, or discriminating between litigants, would not be a lawful means of giving effect to the mandate in Section 190. Performance management frameworks must be designed and implemented in a way that answers to the law rather than contradicting it. In this regard, it is important to emphasize that performance management in the judiciary is not concerned with judicial decisions or the content of judicial decisions. Judicial independence remains inviolable under Section 164 of the Constitution. Performance management is concerned with the administrative and organizational dimensions of judicial service. That is to say, the timeliness of processes, the efficiency of case management, the accessibility of the courts to the public, the effectiveness of registry operations, and the integrity and competence with which public office responsibilities are discharged. The outcome of such performances is an efficient judicial system that answers to the needs and requirements of court users, where judgments are delivered without delays, matters are processed, adjudicated on, and finalized promptly, and the judicial system is generally effective. Thus, whilst judicial officers retain their independence, it is imperative that they must be accountable through the law to the people from whom they derive judicial authority expressed in law. It is the accountability principle that assumes its existence through performance assessments. It must be understood that judicial independence and judicial accountability, though they are different, are mutual concepts that do not conflict, but rather complement each other in enhancing the rule of law. A central feature of performance management is that it focuses on the people who are actually providing the service by discharging their duties. The system must be designed and implemented with a people-centered, strategic focus that directly incorporates the well-being and the emotional needs of members of the judicial service. An organization that prioritizes the conditions of work and members' welfare strengthens its own sustainability. When members of the judicial service are genuinely happy, the chances of achieving higher productivity and sustained performance correspondingly increase. In the matrix of performance management, staff welfare is therefore never to be considered as a side program, but as a strategic priority and an integral part of the performance management cycle. Wellness initiatives such as monthly wellness days and targeted health programs, which the Commission has adopted, are investments that directly support sustained, high-quality performance by ensuring that its workforce remains resilient, engaged, and capable of meeting the heavy and unrelenting demands of justice delivery. When individual members of the judicial service are able to perform their tasks optimally at their respective stations, The result is that each station which performs well feeds into the broader achievements of the entire court system. Ultimately, it is the judiciary that produces good results through the work output of its constituent members. It is therefore imperative that the correct number of competent staff is deployed at every station so that they are able to undertake their tasks adequately. Staff shortages invariably overwork the few members in post and may cause staff demotivation. If that happens, it will inevitably result in poor work output. Over the last decade, the judiciary has embarked on massive decentralization programs for most of its operations, particularly in the High Court and the Magistrates' Courts. New Magistrates' Court stations were opened in many districts across the country. New seats of the High Court were established in provinces in addition to the streamlining of the High Court itself into specialized divisions, which include the commercial and the anti-corruption divisions in Harare. The decentralization trajectory has unfortunately not been supported with a corresponding increase in the deployment of both judicial and support staff. The number of judges and magistrates in the country has barely increased despite the opening of new courts. Any recruitment that has been taken over the years was intended to cover the gaps brought about by various forms of staff attrition, such as deaths, discharges, retirements, and resignations. The population of Zimbabwe has risen to over 16 million people. It is not ideal that such a large population expects both its criminal and civil dispute resolutions to be shouldered by a paltry 80 judges and 250 magistrates. The untenable situation is made worse by the fact that Zimbabweans are an enlightened people who have embraced modern ways of dispute resolution. More often than not, they turn to the courts for the determination of conflicts. This point will become evident when the performance of the courts and the workload are discussed later in the address. The misalignment of staffing levels and the workload significantly contributes to delays and may compromise both quantitative and qualitative service delivery. The Commission's human resource base ought to expand at the same pace that the court network is growing. Only then can the performance management standards outlined earlier be realistically and equitably measured across the entire judicial service. The theme adopted for 2026 is expected to be a catalyst for bridging the gap in inadequate staff deployment. The number of judges and magistrates in post must be dramatically increased if the judiciary is to continue performing its constitutional mandate. The second enabler of the 2026 theme is the use of information and communication technology. There is no turning back regarding reliance on technology in the courts. That technology is a necessary tool which enhances efficiency in the courts is now common course. Over the past 4 years, the judiciary has gone into overdrive in the adoption of technology and deploying it to enhance court operations. The advent of IECMS in the courts has been the sine qua non of the successes recorded in court operations. Technology directly advances the constitutional standards of quality, inclusivity, and sustainability. When properly deployed, it promotes swiftness as well as the efficient, accessible, and transparent delivery of justice. It promotes effective registry management, shortens delays in the consolidation of court records, widens access to justice through virtual hearings, and strengthens transparency. The use of ICT also reduces the amount of human intervention in court processes, which in turn mitigates the incident and likelihood of error or corruption in the administration of justice. The IECMS already facilitates electronic filing, case scheduling, virtual hearings, and the generation of judicial statistics. It provides an auditable trail of actions taken on any given case, thereby strengthening accountability. Virtual hearings reduce travel burdens and allow legal practitioners, parties, and witnesses from remote locations to participate in proceedings without the need to be always physically present at a court. Internet hubs that have been established across the magistrate court and other institutions provide connectivity which supports these services. In these and other ways, technology is being used to widen access to justice, promote efficiency, and support the smooth functioning of the courts. Over the last 5 years, the judiciary has placed emphasis and focus on the deployment of the IECMS in the courts. All the superior courts are now paperless. In addition, 4 magisterial provinces were also recently digitized under the 4th phase of the IECMS implementation. That trajectory will continue during the year under review in order to fulfill the objectives of the adopted theme. Work will immediately commence to prepare for the next provinces, being Manicaland and Mashonaland East, for the deployment of the IECMS in the Magistrates' Court. The use of ICT in the judiciary should not be the preserve of the court alone. ICT is intended to enhance performance of the entire judicial service. It must therefore apply across all institutions under the Commission's purview. The expectation is that all departments in the judicial service must leverage technology in order to ensure quality, inclusivity, and sustainability. No place and no department will be left behind in that respect. To demonstrate that commitment, departments such as finance have already digitized some of their operations under the IECMS, and other digital systems such as SED, Pastel, and SAP, which are used to process payments and interact with Treasury. The Human Resources Department uses the Human Resources Management System to capture and store employee information. It is also used in promotional decisions and transfers of members of staff. The Judicial Training Institute relies on the e-learning management system as a repository for training materials and management of training. The Transport Department uses the fleet management system to manage the Commission's fleet. The Procurement Department uses the electronic government procurement system to conduct procurement processes and interact with the Procurement Regulatory Authority of Zimbabwe. The Corporate Department manages the Commission's website and social media platforms to interact and share information with litigants and the general public. Sadly, some departments still operate on either wholly manual or semi-digitalized platform. That needs to change because the expectation is that the operations of all departments must become electronic in one way or another. The theme adopted for 2026 is therefore a clarion call for all the departments in the Commission which are yet to digitize their operations to be innovative. They must consider the adoption of various technological applications and software that would enhance their operational output and efficiency. Gone must be the days when, for instance, the management of payrolls and leave days in the Human Resources Department, or the purchase of spares and management of vehicle service under the Transport Department, or the asset and stores management done in the Administration Department, or the editing and preparation of judgments for publication done by the Law Reporting Unit, to name but a few, continue to be done manually. The total digitization of court processes and other operations in the Commission comes with the realization of the dynamism of technology. What that entails is that the Commission must be ready to embrace, deploy, and leverage artificial intelligence. The use of AI involves the imitation of human capacity for abstraction in computers. That enables the machines to think logically, solve problems, and undertake tasks which previously could only be done by human beings. The deployment of AI to enforce court operations and processes has become central in many jurisdictions globally. It would be folly, therefore, for the judiciary in Zimbabwe to ignore and wish away that new phenomenon. Where AI can be used to quicken processes, to enhance accuracy, and to extract better and more qualitative data, amongst other justifications, it is important that the judiciary should rely on AI in order to provide better quality service to the generality of the populace, particularly those that visit the courts. The Commission has since commenced using AI in the recording and subsequent transcription of court proceedings. The expectation is that it will also be used in other areas such as registry, research, and support services as the Commission moves forward. On a cautionary note, it is emphasized that reliance on AI comes with its own pitfalls if it is not done with necessary circumspection. It can easily give distorted results. In the judicial context, AI comes with risks such as algorithmic bias. An artificial intelligence system trained on biased data or designed by persons with prejudiced assumptions may produce outcomes that are as biased as its creators. Proper policies and guidelines will therefore be put in place to regulate the reliance on and use of AI in the judicial service. The sustainability of technology is an instrument of progress in the judiciary. It must be supported as a matter of principle by a viable and dynamic information and communication technology department. A well-capacitated IC department should be able to drive the ICT trajectory being adopted by the Judicial Service. It is important that the department is well capacitated by deploying ICT experts of various specialties who are able to drive the technological development agenda of the Judicial Service. In line with the innovation thrust adopted, the Commission will soon be employing a highly qualified person at the level of Deputy Secretary to direct ICT operations. That person will occupy the position of Deputy Secretary, ICT, Innovation, and Corporate Services. The deployment of such properly qualified experts is one way the Commission can be assured of the sustainability of its ICT program. Before turning to the operational achievements of the Commission during the year 2025, it is important to share with the nation the Commission's and the judiciary's deep sorrow at the loss of judicial officers and other members of staff suffered in the past year. On 22 November 2025, we lost a serving member of the Supreme Court, the Honorable Ms. Felicia Chatukuta, Judge of Appeal. She passed on in Harare at the age of 63 years. Justice Chatukuta was appointed as a judge of the High Court on 29 August 2005 and served in that capacity with distinction for 16 years before her elevation to the Supreme Court on 3 June 2021. After obtaining a Bachelor of Laws degree from the University of Zimbabwe in 1985, she served as a prosecutor, a part-time lecturer at the University of Zimbabwe, and a director of the Legal Aid Directorate. Throughout her judicial tenure, she was known for diligence, humility, and an unwavering commitment to justice. Her passing on while in active service on the Supreme Court bench has left a significant void in the judiciary and in the broader legal fraternity. During the same period, the judiciary was also plunged into mourning with the passing on of Zimbabwe's first black female High Court judge, the late Honorable Mrs. Justice Mavis Dorothy Gibson, who died in London, England, on 21 May 2025 at the age of 85 years. Justice Gibson was appointed as a judge of the Administrative Court on 1 March 1984 before joining the High Court bench on 15 May 1984. She served as a judge of the High Court of Zimbabwe for 12 years before continuing her judicial service in the Judicial of Namibia until her retirement in 2001. The judicial further learned with profound sadness of the death of the Honorable Mr. Justice Herbert Mandela, retired senior judge of the Administrative Court, who passed away in Harare on 4 October 2025. Justice Mandela was appointed as a magistrate in 1988, rose through the ranks to become a regional magistrate in 1998, and served as the Chief Magistrate of Zimbabwe from 2005 to 2009. He was appointed as a judge of the Administrative Court on 26 May 2009, a position he held until his retirement in 2024. Another notable jurist, the Honorable Mr. Justice Moses Wungwe Chinengo, died in Masvingo on 19 September 2025. Justice Chinengo was appointed to the High Court bench on 26 February 1996 and served until 29 February 2004, after which he continued to render judicial service in the region, including the courts of Botswana, Lesotho, and Namibia. The Commission also announces with sadness the loss of 8 members who held various positions of responsibility within the judicial service. 7 of those members were in the Magistrates Department, while 1 was from the Superior Courts Department. As the Commission mourns these valued sons and daughters, we do so in recognition of the great work and service they rendered through judicial service to the people of Zimbabwe. May their souls rest in eternal peace. The Commission also announces that Honorable Mrs. Yuna Makamure retired from the Labour Court of Zimbabwe on 14 December 2025. At the time of her retirement, she was serving as a judge of the Labour Court and at different times as its acting head. Her retirement marked the conclusion of an illustrious career as a judicial officer spanning a period of more than 2 decades. As she takes her well-deserved rest, we wish her comfort and good health. At an appropriate stage, before the adjournment of this special sitting, the gathering will be invited to stand to observe a moment of silence in honor of the late Honorable Justice Felicia Chatukuta and all the members of the Judicial Service who passed on during the course of the year. Earlier on in the address, I intimated that the JSC 2021 to 2025 strategic plan came to an end on 31 December 2025. It therefore became imperative that the Commission commenced the process of developing the next cycle of its strategic plan, which will run for the period 2026 to 2030. That process was concluded in December 2025. The launch of the Commission's 2026 to 2030 strategic plan is today. The Commission decided to share with stakeholders and the nation the roadmap that will guide its operations under the 2026 to 2030 strategic plan as the judiciary plays its role in the fulfillment of the National Vision 2030. The strategic plan is a product of an extensive process of institutional reflection and consultations. Judges, magistrates, heads of departments, and members of staff of the Judicial Service participated in organized discussions on the state of the administration of justice in Zimbabwe and the demands of the Constitution and the expectations of the people. Their contributions were complemented by inputs from key justice stakeholders who interact daily with the courts. Throughout this process, care was taken to align the strategic plan with the Constitution, the National Development Strategy No. 2, and relevant regional and international instruments that speak to the rule of law, access to justice, and good governance. At the same time, it was ensured that the new strategic plan responds candidly to the challenges identified in the situational analysis, including pressures on human capital, wellness, institutional capacity, and sustainability of reforms. The strategic plan organizes the work of the Judicial Service into clear strategic priority areas that speak to the quality of adjudication and court administration, expanded access to justice, digital transformation, the strengthening of customary and local justice, improved governance and performance management, and the welfare, wellness, and security of judicial officers and staff. Across these priorities, performance management and technology are expressly identified as cross-cutting means that must be applied lawfully and scientifically. The strategic plan sets out concrete outcomes and measurable targets which give practical effect to the commitment to quality, inclusivity, and sustainability in judicial service. Among other objectives, it envisaged a marked increase in the proportion of the population which is able to access justice, improvements in case disposal rates, the complete digitization of the courts over the space of 5 years. In substance, the strategic plan is a contract between the judicial service and the people of Zimbabwe for the period 2026 to 2030. It is the roadmap against which the achievements and challenges that follow in the address must be understood. The hard work done by various stakeholders in the development of the strategic plan, particularly the Commission Secretariat, which partnered with the European Union and the consultants IBF Impact and GGF Africa Consortium, whose analytical depth and facilitation of skills guided the situational analysis, stakeholder consultations, and the strategic planning processes, is gratefully acknowledged. After this ceremony, copies of the strategic plan will be shared with all guests. I urge each of you to get a copy before you leave. Copies of the strategic plan have also been distributed to all the stations where similar ceremonies are taking place. The capacitation of the bench was a key development in 2025. During the period under review, the Commission facilitated the appointment of 6 honorable judges of the Labour Court. They are the Honorable Mr. Justice Rodin Zieche, the Honorable Ms. Justice Evidence Gonesi, the Honorable Mr. Justice Moshin Jaravani, the Honorable Mr. Justice Clever Garikai Tsikwa, the Honorable Mr. Garizo Ziatuma, and the Honorable Ms. Justice Bianca Makwande. The appointments reinforced the capacity of the Labour Court to deal with labor disputes timelessly and to contribute to the development of sound labor jurisprudence in Zimbabwe. The judiciary congratulates the honorable judges on their appointment and wishes them success as they undertake this important constitutional responsibility. In addition to these appointments, the Commission continued to strengthen the Magistrates' Court, which is often the first point of interaction with the justice system for most litigants. 7 new regional magistrates, comprising 4 women and 3 men, were appointed. The promotion of the 7 magistrates eased pressure on existing regional magistrates, improved the distribution of work, and furthered the objective of gender representation within the judiciary. Cumulatively, the appointments into the Labour Court and the regional courts represent a deliberate effort to ensure that the courts are adequately capacitated and capable of delivering quality justice in line with the Commission's constitutional mandate. But modern, accessible, and properly equipped courts are an essential component of quality, inclusive, and sustainable judicial service. In 2025, the Commission recorded significant progress in the construction, refurbishment, and upgrading of court buildings across the country. A notable milestone at Mtawatawa Magistrates Court by the Secretary of the Judicial Service Commission on 4 April 2025. The new courthouse comprises a courtroom, offices, a cell block, ablution facilities, and a waiting area. It has been designed to support the IECMS. Its completion has brought justice services closer to the local communities. During the year, considerable progress was also made on several other key infrastructure projects. Construction of the Kwekwe Court Complex, which will comprise 4 courtrooms and 18 offices, advanced significantly. The superstructure and roofing were completed. Currently, the contractor is working on the finishings. The expectation is that the courthouse will be commissioned during the first half of the year. In the same vein, it is advised that the Kwekwe complex will allow for the opening of the 6th seat of the High Court at Kwekwe. The Midland Province has had a high number of both criminal and civil cases, which are currently being heard at the Bulawayo High Court station. The extraordinary sittings of the High Court on 2nd at Gweru and Gokwe are reported elsewhere in the address. That initiative was undertaken in an attempt to deal with the ever-increasing number of murder cases in the Midlands province. The Commission, like other stakeholders, is certain that the setting up of a High Court seat at Kwekwe, will not only solve the challenges in the Midlands, but will also be the panacea to easing the ever-increasing workload at Bulawayo High Court, where judges are currently dealing with a high number of cases. It is important, however, to indicate that the decision to locate high courts in complexes designed for use by magistrates' courts does not, as a matter of policy, stop the Commission and government from building standalone high courts in the affected provinces in the future when resources permit. At Mavuku Tafara Magistrates Court, progress was made on the new complex under construction. Upon its completion, the complex will house 18 offices and associated facilities. It is expected that the courthouse will be commissioned by the second quarter of 2026. The construction at Gwanda Court Complex project, which includes 8 courtrooms, steadily progressed. It is expected to be completed in the course of this year. At Cowdrey Park, the construction of a courthouse with offices, a cell block, and a guardhouse progressed well. The project, however, experienced delays due to poor performance by the contractor, necessitating arrangements for the appointment of a new one. The Commission also continues to invest in facilities that support specialized court functions. At Beitbridge, the extension of the Magistrates Court included the creation of an additional courtroom and related civil court facilities, together with offices that will house an IECMS hub. In Bulawayo, work proceeded on the expansion of the Cape to Cairo building, which accommodates the Sheriff's Office, to create additional offices and a boardroom for the Commission's Secretariat and a mediation center for the Southern region. Together with the ongoing work on the Sheriff's infrastructure in Harare, these developments signal a consistent modernization of court facilities in support of an accessible, efficient, and technology-enabled system of justice delivery. Another notable development in 2025 was the continued implementation of the IECMS in the Magistrates Court. The year under review saw the execution of 4.1 and execution of phase 4.1 and phase 4.2 of the rollout, marking a decisive shift towards a fully digitized magistrates court system. Under phase 4.1, which was launched on 1 July 2025, magistrates court in Mashonaland Central and Matabeleland North provinces were integrated into the IECMS platform. Building on this progress, phase 4.2 was launched on 1 October 2025, extending the IECMS to magistrates court in Masvingo and Matabeleland South provinces. 10 court stations in Masvingo and 6 in Matabeleland South were digitized, allowing for electronic filing, case tracking, virtual proceedings, and improved communication with litigants and legal practitioners. The effect of these deployments is that all superior courts and magistrates courts across the 4 mentioned provinces are now operating on the digital platform. This development has eliminated many geographical barriers to access justice, reduced delays associated with paper-based processes, and created a more transparent and accountable record-keeping environment in line with the enablers of quality, inclusivity, and sustainability that the judiciary seeks to entrench. The rollout has been accompanied by intensive training programs for magistrate and court staff, ensuring that the IECMS is understood and effectively utilized in daily judicial operations. These measures have strengthened the capacity of the lower court to manage growing caseloads, improved the timelines of judgment and orders, and enhanced the ability of court users to follow the progress of their matters electronically. Looking ahead, the Commission will proceed with phase 4.3 of the IECMS implementation, which will operationalize the IECMS in magistrates' courts in Mashonaland East and Manicaland provinces during the first half of the year. The next phase will move the judiciary closer to truly national electronic case management system that brings digital justice within reach of communities across all provinces. At the beginning of the year, the Commission adopted a policy to implement a court-annexed alternative dispute resolution system with a focus on mediation to enhance the efficiency of justice delivery. This progressive initiative, successfully adopted in many jurisdictions worldwide, will apply to both civil and criminal cases. Pursuant to this initiative, a committee was set up, chaired by a judge of the High Court, comprising representatives from key justice sector institutions, including the JSC, the Chief Magistrate's Office, the NPA, the ZAC, the ZRP, the Ministry of Justice, Legal and Parliamentary Affairs, the ZPCS, the Attorney General's Office, and 2 ADR legal practitioners to develop recommendations on how the ADR process can be implemented in the courts in Zimbabwe. Critical implementation components include revising legal frameworks, developing training programs for personnel, creating comprehensive handbooks for civil pre-diversion and criminal plea bargaining, and organizing benchmarking visits to jurisdictions with established ADR systems. A benchmarking visit to Namibia was undertaken from 14 to 19 September 2025. The ADR implementation process will culminate in an official program launch positioning Zimbabwe's justice system to deliver more efficient and accessible alternative dispute resolution services focusing on a court-annexed mediation in civil matters and mediation in criminal matters. Now, I turn to the performance of the courts briefly. All the courts received increased numbers of both criminal and civil cases during the period under review when compared to the previous year. The observation made is that as the economy continues to improve, the enhanced economic activities also result in increased numbers of civil disputes and criminal cases, particularly those involving dishonesty, such as fraud. Increased numbers in civil cases are also reflective of a society that has become highly aware of its rights and the fact that such rights can be vindicated in the courts. In circumstances of such increased litigation, the courts must be seen to be reacting positively by adjudicating on and finalizing matters filed in registries promptly with little or no delays. It is such reactions by the courts that ensure that a corresponding high number of cases are completed and the backlog of cases in the court is kept under check. A bird's-eye view assessment of the performances of the court shows that there were exceptional performances by judges across all the superior courts and by magistrates. The backlogs were kept under check in all courts during the course of the year, except in the civil courts, in the magistrates' courts. The magistrate court started the year with 7,315 criminal cases and closed with a balance of 7,701, increasing its backlog by 386 cases. There has been a marginal increase in cases driven by festive season when a high number of cases are reported and then closed intermittently. The magistrates' civil court started the year with 863 civil cases and closed with a balance of 6,174, increasing its backlog by 5,311 cases. It is a matter of concern that the backlog of civil cases in the magistrates' court has increased. The court received a high number of summons from local authorities during the last quarter of the year. Investigations have revealed that there has been also poor supervision of performance by the responsible officials in the hierarchy of the magistracy and unnecessary postponement of cases. Measures have now been put in place to ensure the court performs better. The superior courts opened the year with 12,514 civil cases and closed with 10,045, reducing their backlog by 2,469 cases for the year 2025. By any standard, these statistics are impressive and reflective of judges together with support staff who applied themselves well. I would like to congratulate them on a job well done. Mention must also be made of some factors that contributed immensely to the disposal of cases during the period. Firstly, it was the issuance of Practice Direction Number 1 of 2025 that authorized the registrars of courts to dispose of all dormant files in registries where parties would have filed matters and then abandoned them. Secondly, it was the setting up of special extraordinary circuit courts in the Midlands province, which targeted a concentration of murder cases that had been pending for some time. Through the temporal deployment of additional judges, prosecutors, and support staff to Gweru and Gokwe, a substantial number of these cases were finalized within a relatively short period, thereby addressing both the backlog and public apprehensions regarding delays in the determination of serious offenses. Thirdly, there was also an increase in reliance on structured research support from the research department. The volume of research undertaken for the magistrate and the superior courts increased significantly, with researchers providing bench memoranda, comparative law material, and case summaries in complex and novel matters. That development eased, in part, the heavy workload on judges. It is expected that over time, it will translate into further strengthening of the quality, consistency, and depth of jurisprudence. Fourthly, the setting up of special anti-drugs and substance abuse courts ensured that drug-related matters, which are on the increase, were dealt with and finalized expeditiously. The resuscitation of fast-track courts in all provinces also contributed immensely to the disposal of a high number of criminal cases. The performances described above should, however, not detract from the comments already made elsewhere in the speech that there is a serious shortage of judges and magistrates in the country. Such shortages are making those in post operate under unbearable pressure. In conclusion, the Commission would not have been able to meet those set objectives for the year and score all the successes reported without the cooperation and collaboration of other government departments and justice sector partners, including civic and development partners. The Commission and the judiciary expressed their sincere appreciation to all partners who worked and continue to work with the judiciary to promote an efficient justice delivery system for the people of Zimbabwe. With these remarks, the gathering is invited to stand and observe a moment of silence in honor of the late Justice Felicia Chatukuta, Judge of Appeal, retired judges who passed on, and all other members of the judicial service who passed on during this past year. After the moment of silence, a word of prayer will be led by Bishop Jeremiah Mangiza of the Methodist Church in Zimbabwe, as guidance is sought from the Almighty for the judiciary in the year ahead. Following the prayer, the special sitting of the court will stand adjourned. I thank you. Yes, thank you.
Let us pray. We thank you, our Heavenly Father, this morning. For you have granted us this day a new season as we remember our colleagues, as we remember our workmates who were executing the duties of justice in this country. We remember them as they departed from us. We committed their spirit in the hands of our Almighty to remember their families until we meet again in heaven. Accept our prayer as we continue continue to do the duty diligently. I pray in the name of the Father, the Son, and the Holy Spirit. Yes, as we are seated, allow me to continue. I shall read from Psalm 72, reading verse 1 and 2, also Proverbs chapter 21, verse 15. Endow the king with your justice, O Lord, the royal son with your righteousness. May he judge your people with righteousness, your afflicted ones with justice. Then Proverbs 21 verse 15 says, when justice is done, it brings joy to the righteous, but terror to the evildoers. Yes, as we begin the new year, the judicial season, may we be reminded of God's call to justice and righteousness. We acknowledge the weight of responsibility that rests on your shoulders. You are entrusted with upholding the law, protecting the rights of all, and promoting justice and fairness in our society. May I remind of God's call to justice and righteousness. Learn to do right, seek justice, defend the oppressed. Number one, I'll talk about God's justice in governance. Psalms ask God to grant justice and righteousness to judges and legal practitioners. Judges and legal practitioners are to reflect God's justice. Number two, righteousness to judgment. Leaders or judges and legal practitioners are to judge with righteousness and justice, prioritizing the affected. Prioritize fairness for those who need it most. Number three, sought God's guidance. As the judicial year begins, this psalm reminds judges and legal practitioners to seek God's guidance for righteous decisions, protecting the vulnerable and upholding justice. Judges seek God's wisdom in decisions. As I conclude, I commit the judges and legal practitioners into the hand of God, and this season to be guided by God. Let us pray. Heavenly Father, we gather today to seek your guidance and blessings as we embark on a new judicial season. Grant our judges and legal practitioners wisdom, integrity, and passion. May they uphold justice and fairness, protect the rights of all, and defend the vulnerable. May our courts be places of refuge and peace, where truth and righteousness prevail. Guide us to act justly, love, mercy, and walk humbly with you, O God. May your presence be with us as we strive to serve with excellence and integrity.